The Honorable Judges of the Court of Appeals of the State of Alaska. The Court of Appeals is now in session.
Good morning. We are here this morning for the argument in Jones v. State, file number A13446. Are the parties ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Counsel, you may begin.
Thank you. And if it may please the court, it is axiomatic that the Fourth Amendment of the Constitution holds that a police officer cannot conduct a search unless there's a reasonable suspicion of criminal activity. When applied to the investigative stop of a vehicle, this court has held that the Fourth Amendment requires that a police officer must have reasonable suspicion in the light of all of the circumstances of a particularized and objective basis for suspecting that a particular person is engaged in criminal activity. So the law is clear. What we're here today to decide is where the floor is for what constitutes reasonable suspicion. There's a lot of case law regarding what is and what isn't reasonable based on different sets of facts. And this court is now being asked to triangulate where Mr. Jones's facts fit into the framework. So let's start by looking at his facts. Mr. Jones was stopped at a traffic light, waiting to make a left turn across a highway. A police officer drove past him, looked in his rearview mirror, and determined that Mr. Jones didn't immediately speed away when the light turned green. Mr. Jones's delay was only a few seconds. He didn't do anything illegal. He didn't do anything unsafe. He didn't even do anything particularly unusual. But the police officer turned around and followed him anyway. Mr. Jones was on an unlit and windy road, late at night, headed home. His driving was admittedly not straight as an arrow, but again, he didn't do anything illegal. He didn't do anything unsafe, and he didn't do anything particularly unusual.
Well, he was driving erratically, according to the judge's findings, correct?
Yes, but I mean, the term erratically can mean a whole bunch of different things. If you look at some of the things that were considered erratic under Navarrete, they were very egregious. And in this case, Mr. Jones's driving, if you look at what the judge found, was he may have crossed the center line a few times and maybe crossed the fog line a few times. He wasn't in oncoming traffic. He wasn't in a position where he was driving particularly dangerously.
Crossing the center line is not dangerous driving?
I would say that it depends on the circumstance and the specifics of how you cross the center line. There's many different ways to cross the center line. You can cross the center line in a highway where there's oncoming traffic, which would certainly be dangerous. Having your left tire hit the center lane on a winding road in the middle of the night where there's no other traffic, is that dangerous? I say that there's perhaps not. So how erratically Mr. Jones is driving, I think, obviously it's a factual issue that the trial court has ruled on, but I think that there's a wide variety of what erratic means.
But you haven't challenged, am I correct that you haven't challenged any of the factual findings? You're just saying as a matter of law, based on the judge's factual findings, that this is not reasonable suspicion. You didn't argue that anything that the judge's factual findings were clearly erroneous. You didn't ask us to, watch the video and determine whether or not the judge's factual findings were clearly erroneous.
Yes, Your Honor. I think that I believe that even if you agree with the factual findings that he was driving erratically, that by itself is not enough to raise reasonable suspicion. So we're not particularly challenging the factual findings, but I don't believe there was a factual finding that Mr. Jones's driving was dangerous, only that it was erratic. And what exactly that means, I leave to the court.
So your position, so the judge's ruling was seeing the judge watch the video and said, basically, anyone looking at this would be concerned that this person was driving drunk. And your position is that as a matter of law, unless there's actual danger that can be quantified, that kind of inference is unacceptable and shouldn't be accepted.
What I'm suggesting is based on the extant case law, driving in a swerving by itself has never been considered to be enough to cause to reach a level of reasonable suspicion. So even if even if he was driving erratically, that's not enough to cause reasonable suspicion. There needs to be something more than that.
But don't we have something more than that? I mean, we have, the stopping at the stoplight and not going forward. So the delay in moving forward, and we have, it's 2:30 in the morning and he's coming from downtown. We have all of those facts.
I agree, Your Honor. And so I think that in total, the police officer justified the stop on 4 things. The fact that there was a short delay making a left turn, the fact that there was moderate swerving, the fact that it was late at night, and the fact that Mr. Jones was headed away from an area that contained bars. So those are the 4 sets of facts that in this case, the court used to justify reasonable suspicion. What I'm saying is that does that set of facts constitute reasonable suspicion in light of all the circumstances that there was a particularized and objective basis for suspecting that Mr. Jones was engaged in criminal activity? And I say that based on the extant case law, no. And I would start by saying, let's look at the cases where courts have found reasonable suspicion. In Abona, the driver was swerving, plus the police officer had just seen the driver come out of a bar and wobble as he walked down the street. In Moran, the driver was swerving, plus he made an illegal left turn. And in Delgado, the driver was swerving, but had also been stopped in the middle of the road for 10 to 15 seconds, which was creating a hazardous obstacle for other drivers. Now, courts have not found reasonable suspicion in a series of other cases, including, for example, Burnett, where the driver was swerving and had rapidly been accelerating, but rapid acceleration was found not to be a violation of traffic laws. In Noble, the driver failed to use a turn signal, which again was not a violation of traffic laws. And Campbell, where the driver didn't have his headlights on, which again was not a violation of traffic laws. Now, in all cases that I found under Alaska law, except for Hammond, the theme seems to be that swerving is one factor that can be used to reach reasonable suspicion, but there needs to be other corroborating indicators. And those corroborating indicators need to be something that's illegal or dangerous or blatant and egregious.
So are you suggesting that swerving, even here, according to the judge's findings, across the center line several times alone is not sufficient, that the police officer had to wait until he posed an actual danger to another driver?
What I would suggest is that there hasn't been a court case that's made that determination yet. And so if we were to go there, that would be a lowering of the standard to something that's below what other cases have found.
I mean, this seems very similar to Hammond, where there was the type of swerving. The vehicle weaved within its lane, saw the vehicle, and the vehicle left its lane of travel and jerked back into the lane. And that was sort of the primary fact. But the other facts were that it was a late hour, and the officer believed that intoxicated drivers were more likely to be on a road at that hour. We said that was sufficient.
Well, the court in Hammond said that the standard should be the same as in Bona.
No, it just used Abona as an example of another case where weaving was an issue, or that's my read of it.
Exactly, but the Abona case didn't find itself that swerving was enough. The Abona case found that swerving plus the fact that Mr. Abona had been seen walking out of a bar minutes prior was enough. And so that the swerving by itself wasn't sufficient. In Hammond, they said that since swerving was enough in Abona, it should be enough here as well. So I'm not sure that the court in Hammond was reading Abona correctly, or didn't factor in the fact that the police officer saw Mr. Abona walking out of a bar before getting into his car.
But you think Hammond rises or falls on Abona? I mean, I read it as using Abona as illustrative, but not necessarily resting on Abona.
I think that looking at the way Hammond was written, using Abona as a basis, the Hammond case doesn't go to Abona and say, doesn't mention the other facts in Abona. It only mentions the one fact in Abona. And that fact in Abona was not sufficient by itself, or we don't know if it was sufficient by itself, to find Mr. Abona guilty. because in Abona's case, there was swerving plus this other factor. And I would say seeing somebody walking out of a bar, wobbling down the street and literally getting into a car is a pretty important factor towards making the determination of reasonable suspicion. The Hammond case didn't talk about that part of the case. It just said that in Abona there was swerving. In many cases, there's swerving, but in all cases, except for Hammond, there's been swerving plus some other factor. And I don't think Hammond didn't seem to understand that the second factor was somewhat important. It just looked at Abona from a swerving issue. And I think similarly, you could look at any of the other cases and say, well, there was swerving in Moran and there was swerving in Delgado and there was swerving in all the other things. But I say that it's the swerving plus other corroborating factors that would make the difference. So that's our opinion on how Hammond should be read. Now, I would say that, Mr. Jones.
I want to make sure you know that you've gone into your rebuttal time, just so you're aware.
Oh, excuse me. Well, I'll lead it to my rebuttal time. Thank you, Your Honor. I think that the state hangs its hat on two other factors that were not related to Mr. Jones's driving. The fact that it was late in the evening and the fact that Mr. Jones was driving away from an area that contained bars. But these are not particularized facts. As we stated in our reply brief, there's bars everywhere. If Mr. Jones had been driving in exactly the opposite direction, he would still be driving away from a bar. In other words, the state would have this court rule that anyone driving anywhere late at night should by definition be suspected of drunk driving, and that's not particularized. And so I'm not sure that's a factor used to be generating reasonable suspicion, because it goes to almost anyone that would be in a car. Now, as I said before, I think the court will determine today where the floor is for reasonable suspicion. And Mr. Jones is arguing the facts of this case are below the facts in other previous cases decided by this court. And it would create a new lower bound for what constitutes reasonable suspicion. And that lower bound may perhaps dip below the Fourth Amendment right regarding searches.
How is it lower than Hammond? It's very similar to Hammond.
And
Hammond's a published case.
Yes, and Hammond, as I said, Hammond relies on Abona. So I think that this case is going to decide on whether or not Abona is controlling over what Hammond says. That's what we laid out as our argument in our briefs.
Okay, I don't read Hammond as resting as squarely on Abona as you do. I agree that there's a discussion of Abona, and I agree that it's limited to the weaving, as you suggest. But it seems like it's used as a C Abona kind of thing, an illustrative point, and not necessarily the definitive reason why the court came to the conclusion it did in Hammond. Well,
again, as I said, we're looking at the totality of the circumstances in this case. And, what are the totality of the circumstances in this case? And, Mr. Jones didn't do anything illegal. You could argue what he was doing was slightly erratic, but he didn't do anything illegal, and it wasn't anything that was actively dangerous because he was on a road that was very deserted. And so even if you get to the point where what he did was erratic, is what he did in the totality of the circumstances enough to get to reasonable suspicion. Now, in Burnett, the court said that an officer's observations must give rise to an objective substantial possibility, and not just a hunch that the driver was driving impaired. And it's our position that the police officer in this case did not have reasonable suspicion. It was more of a hunch, and that would not be enough. So thank you. That's my argument for today. So thank you for your time. Unless there's more questions.
Mr. Bravo?
May it please the court. My name is Ryan Bravo, and I represent the state of Alaska in this appeal. Judge Pallenberg correctly found that Juneau Police Sergeant Sterling Salisbury had reasonable suspicion to investigate Scott Jones for driving under the influence. It was 2:30 in the morning on a Saturday when Sergeant Salisbury observed Jones coming from downtown Juneau, an area of town saturated with bars at a time when not much is open besides those bars. Sergeant Salisbury saw Jones stop at a red light, but when the light turned green, Jones did not move into the intersection for about 3 to 4 seconds. Judge Pallenberg described this as an appreciable period of time based on the testimony that occurred in the evidentiary hearing. Sergeant Salisbury found this behavior to be suspicious due to the way that alcohol acts as a central nervous system depressant. So acting prudently, Sergeant Salisbury began to follow Jones. While doing that, he saw Jones swerve on the roadway. At the evidentiary hearing in this matter, Judge Pallenberg watched the video, and he also had Sergeant Salisbury in the courtroom testifying, giving commentary as he was watching. Judge Pallenberg described Jones's driving as, and I quote, a good bit of veering back and forth from one side of the lane of travel and then across it to the other side, back to the center lane, over to the center lane again. He ultimately said, and again, I quote, any untrained driver behind someone under those circumstances would wonder if the person doing that had been drinking. As this court is aware, reasonable suspicion is not an onerous standard. It allows officers to instigate an investigatory stop when the officer has some minimal level of objective justification based on articulable facts and under the totality of the circumstances. Here, the facts already articulated meet that threshold. Not only did Sergeant Salisbury have a reason to stop Jones as Jones swerved down the road at 2:30 in the morning, in fact, Sergeant Salisbury would have been derelict in his duties had he not stopped Jones. Anyone driving in the manner where any untrained driver would wonder if they have been drinking is the exact type of investigatory stop that society expects its officers to undertake. Therefore, Judge Pallenberg was correct when he found that Sergeant Salisbury had a reasonable suspicion to investigate Jones on that night. Besides that, I'd like to reserve the rest of my time for any questions this court may have, or else I'll rest on the state's briefing.
Thank you, Mr. Bravo.
Thank you.
I think there are no questions, so we can return to Mr. Peloso.
Thank you, Your Honor. I'm not sure how much time I only have a few seconds left.
You have a minute.
The only thing I would say, Your Honors, is that Officer Salisbury at trial was unable to say that Mr. Jones was driving negligently. I think that there's a big difference between driving, say, in some of the Navarrete cases where there was someone crossing the median lane of a highway into oncoming traffic, and somebody who late at night is driving down a deserted road that's kind of windy, has lights coming up from behind them, and somehow just tips across the center line. If Mr. Jones was not, and crossing the center line, as I pointed out in my briefing, is not illegal under CBJ ordinance. So if what Mr. Jones was doing was not illegal and Officer Salisbury said it was not negligent, then how does that get to reasonable suspicion? So that would be my question, or my question for you. And I'm out of time, so thank you.
Thank you, counsel. We take this matter under advisement and we stand adjourned.
Thank you, Your Honors.
Thank you.